The PSI of Haswali police station. On the basis of exhibit P4, PW13 registered the FIR against the appellant, against the accused. FIR as per exhibit company. FIR as per exhibit PSI, sorry, exhibit P21. Then the accused was arrested on the basis of his voluntary statement. The place where the dead body was buried was discovered. Then IO on giving requisition to PW16. The Talaka Executive Magistrate got the body exhumed under the Mahzar Exhibit P5. The presence of PW10, the doctor, PW6 and 8, the Mahzar witnesses. P5 ಅಂತ ಹೇಳಿದಲ್ಲ, P5 ಅಂತ ಹೇಳಿ the Mahzar. Then PW10, the doctor conducted the then PW16 conducted the inquest Mahzar on the dead body as per exhibit P29. Thereafter, PW10 conducted the postmortem on the dead body and submitted the PM report as per exhibit P22. On the basis of the voluntary statement of the accused, the bloodstained clothes of the spot Mahzar was conducted in the house of the accused, and his blood-stained clothes of the accused and the victim were recovered. On the basis of his voluntary statement, MO6, the weapon of offense, was recovered. ಇದು ಬಟ್ಟೆ ರಿಕವರ್ ಮಾಡಿದ್ದೇವೆ ಅಂತ ಮಂಜರಿ P11 ಅಂತ ಮಾಡಿದ್ದೇವೆ. Weapon amount was recovered under the Mahzar Exhibit P12. Weapon of offense was recovered under the Mahzar Exhibit P12 in the presence of PW16. Offense witness. Further, the bike used to accused in the commission of offense where the accused was seized under the Mahzar Exhibit P17 in the presence of PW6. the other witness, for conducting the investigation. The police had a charge sheet. Next one. This accused disputed the charges and claimed the trial was tried in the trial court for the charges. For the charges punishable under section 302 and 201 IPC. In support of the prosecution case, W1 to 19 were examined. Exhibit P1 to 47 and M1 to 13 were marked. The trial the accused was examined under section 313 CRPC. He did not read the defense evidence. The trial court, on hearing the parties, by the impugned judgment and order, convicted the accused for the offences punishable under section 304 and 201 IPC. The trial court held that the accused caused the death of the victim by assaulting her as contended by the prosecution. However, the trial court held that the accused had the knowledge that such assault may cause death, but he had no intention to commit murder. Therefore, was charged for the offense under section 302 IPC. He was sentenced to the offense punishable under section 304 IPC. Further, the trial court sentenced the accused for imprisonment of 10 years and fine of Rs 10,000 for the offense punishable under Further, the trial court, by the impugned order, sentenced the accused as follows. Submissions of so-and-so 11% for the appellant. The accused was physically the accused has a physical handicap in his right hand. Therefore, the theory of he assaulting the victim causing her injuries is improbable. Please delay in filing the complaint. There are material witnesses have not prosecuted and so have not supported the prosecution case. Recovery hazard witnesses were not independent witnesses. The evidence of solitary eyewitness was not credible. There were lots of contradictions, omissions, and commissions in her evidence. The witnesses were tutored. Chemo6 is not sufficient to cause the injuries mentioned in the cause the injuries as alleged by them, as alleged by the prosecution. The victim had suffered the injuries accidentally. They were not homicidal injuries. As per the prosecution itself, the accused took care of the deceased and her children for 2 years. Therefore, there cannot be any intention for him to kill her. As per the prosecution case itself, there are many mitigating circumstances. Therefore, the sentence of imprisonment is disproportionate. Next one. The submissions of so and so learned is safety. PW7 being the daughter of the deceased, her presence at the scene of offense with accused and deceased is natural. Since the time of filing the complaint, she has implicated the accused as the assailant. Her evidence was corroborated by the evidence of PW19, the judicial magistrate who recorded her statement under section 164 CRPC. There was further corroborated by the medical evidence and the evidence of PW 3, 4, and the other witnesses. When the deceased was living with the accused in his house, he should explain her death. The fact of he not intimating the relatives of the deceased, not filing any, not informing the police about her death, shows his involvement in the case. The circumstance, the circumstantial evidence regarding the recovery of dead body, weapon of offense, other incriminating material was proved via
the circumstantial evidence regarding
other circumstances like motive were proved beyond reasonable doubt. Therefore, the improved order of conviction and sentence does not call for interference. The accused was not totally disabled. He was working. He has a minor disability in his right hand. There are no reasons for it. Having regard to the submissions of both sides and the perusal of the records and the material on it, the question that arises for consideration is whether the impugned order of conviction and sentence is sustainable in life. Yes, ma'am. The, the analysis into the thing. At the outset, it has to be stated that the accused did not dispute the relationship between himself, PW7, himself, and deceased. Between deceased PW7 and PW5, he also did not dispute that he lived with the deceased and her children for 2 years prior to the incident. He also did not dispute the death of the victim or the injuries on her dead body. His only contention was that the said injuries were accidental one. In the cross-examination of witnesses as well as in his examination under section 313 CRPC, he claimed that there was a nala near the house. He further claimed that on the day of incident, when he returned home, he found 3 persons going outside the house and liquor sachets in his house. His further defense is that he found the victim crying from the nearby Nala. He brought her back on the vehicle of he further claimed that on the vehicle of PW his uncle. He tried to shift the injured to the hospital, Vadapalapur hospital. In the middle of the road, the fuel exhausted. Therefore, and he died on the way. He also admitted the presence of. He also admitted PW7 accompanying them during all this process. He claimed that the way she died, and he brought back the body and laid that on the slab of the village. Villagers, an inquiry, he informed the villagers, and villagers themselves, he along with the villagers cremated the dead body. Therefore, the prime question that raised for consideration is whether the death was homicidal or accidental. The case of the prosecution was based on number 1, the evidence of PW7, the eyewitness. Number 2, the medical evidence. Medical evidence. The circumstance of motive. Number 3, circumstance of recovery of dead body. Next, recovery of weapon of offense, recovery of blood stain clothes of the deceased, medical evidence regarding the cause of death, the evidence of PW3 and 4, the owner of the bike and the village doctor, who declined to whom the accused took PW, the deceased for treatment. Next one. Rightly observed by the trial court, when there is a eyewitness to the incident, the circumstantial evidence, even if it is weak, takes a back seat. As far as delay in filing the complaint, admittedly, the deceased was living with the accused. Deceased, along with PW7, was living with the accused in a far-off place from her parental house. Material on record show that virtually she was an orphan. Therefore, she had to take shelter initially with one Puttaramaya and later with the accused because of her social and financial conditions. PW, the only person who was living with her, other than the accused, was PW7, her daughter, aged 7 years. At the time of incident, she was 7 years. No? At the time of incident, she was 7 years. She was aged 7 years. She was aged 7 years at the time of the incident. The evidence on record further shows that PW, the deceased, accused, and PW7 lived at several houses by way of temporary arrangement. Under such circumstance, the only eyewitness, only a child, filing the complaint after seeing the incident,
Under such circumstances, the only
the evidence on record shows that even after burying the dead body, the accused took care of PW7. Such child informing others or going to the police station and filing the complaint is beyond the imagination of an ordinary prudent man. It's only when PW 5 visited their house and inquired PW 7, the incident came to the light. So thereafter, he has filed the complaint on 21/12/2014. Therefore, the trial court rightly held that the said delay itself does not demolish the case of the prosecution. So far as PW7, the solitary witness, the complaint was filed on 21/12/2014 at 5:45 p.m. The statement of the IO got the statement of PW7 recorded the section 164 CRPC on 31/12/2014. In her statement, she implicated the accused as the author of the death. She also narrated all the events. She also narrated the incident in the order of events. Recording of such statement was proved by the evidence of PW. Magistrate is PW. PW 19 ಅಲ್ಲ
PW16. Requisition to PW16 Taluka Executive Magistrate.
Magistrate judicial magistrate. PW 19. PW 19 ಅಲ್ಲ judicial. Yes. We will come to that also. Then ಅದಕ್ಕೆ ಇವರು ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಮತ್ತೆ ಇವ್ರು ಮಾಡಿದಾರಲ್ಲ ಕೋರ್ಟ್ ಕ್ವಶನ್ court itself has asked the question. Much was sought to be made referring to the cross examination of PW7. In the chief examination, PW7 spoke according to the prosecution version. She also speaks about the accused shifting, taking her and the victim on motorbike, taking them to PW PW4, the doctor, and again coming back and her mother dying on the road, on the way. She further speaks about the accused keeping the dead body under the tree for 2 days and then burying her. Thereafter, he going for the work. He also identified MO6. It's no doubt true that the cross-examination he said that ಇವ್ರು ಹೇಳ್ಕೊಟ್ಟಾಗೆ ಹೇಳಿಕೆ ಕೊಟ್ಟಿರುತ್ತೆ, ಹೇಳ್ಕೊಟ್ಟಾಗೆ ಹೇಳಿದ್ದಾರೆ ಅಂತ ಹೇಳಿದ್ರು ಪ್ರಾಸಿಕ್ಯೂಟರ್. ಅಂಡ್ she said that morning, on that day morning, the public prosecutor and the sister of the school told her what has to be deposed before the court, and she deposed accordingly. But the accused himself, so the defense counsel himself suggested in the cross-examination of PW7 that there was there were quarrels between the accused and the deceased before the incident in question. He also suggested that on the day of incident, two persons came to the house and consumed liquor, and on noticing the arrival of the accused, they ran away. He himself suggested that the accused inquired with her mother about those persons, and in that regard, quarrel took place between them. He also suggested that during that quarrel, her mother packed up her clothes and tried to run away. She admitted all those suggestions, and they support the case of the prosecution with regard to motive. She also admitted the suggestion that in the process of running, she fell down. Cried. Therefore, herself and the accused shifted her to the hospital. He himself suggests to her about he taking to the hospital and the exhaustion of the fuel in the vehicle. They coming back and laying the body of her mother on the platform of people tree. They were all admitted. It's material to note that the chief examination, it is material to note that before the cross-examination, her cross-examination by the defense counsel, the chief examination and the cross-examination conducted by the learned public prosecutor, on treating her as hostile witness, she admitted. Chief examination I'm sorry, separately.
In the chief examination and the cross-examination.
In chief examination, she clearly implicated the accused as the assailant of her mother and assaulting her on legs with hemostics, causing fractures, bleeding injuries, etc. The prosecutor treated her as hostile witness and cross-examined. Even in that cross-examination, she admitted the manner in which the accused assaulted her mother. When she gave a go-by in her cross-examination by the defense, that court to get the clarity, put her questions, certain questions, and got the answer. During for the court questions, she said that the accused, her mother died due to the assault of the accused by Ragib al-Bar.
6.
M6 ಅಂತ ಹೇಳಿಲ್ಲ ಅದಕ್ಕೆ by the Ragib al-Bar. Ragib. Therefore, even if there were some inconsistencies in her in her evidence, the trial court did not find them fatal to the prosecution case. No PW1 and 2 turned hostile regarding the motive aspect. The suggestions made by the accused to PW7 themselves proved the circumstance of motive. Further, the evidence of PW1 was corroborated by the evidence of PW3, the owner of the bike, and PW4, the doctor who declined to treat the victim. PW3 is none else but the cousin brother of the accused. He deposed that during the night of incident, the accused borrowed his bike, representing that PW7 has suffered injuries and she has to be taken to the hospital. if at all, if at all, the victim suffered accidental injuries, she was to be taken to the hospital. There was no reason for the accused to borrow the bike in the false pretext of taking PW, taking the victim to the hospital. Sorry, taking PW7 to the hospital. That conduct of the accused also counts. Since PW3 was not cross-examined, his evidence with regard to the accused borrowing the bike in the false pretext of getting treatment for PW7 went uncontroverted. Borrowing the bike and then returning the same in the morning went uncontroverted. PW4, a local doctor who's that on the day of incident, on the day of incident at 12 midnight, the accused, along with one girl and a woman, came on a motorbike. Further deposed that the accused represented that the woman suffered injuries by tripping on wire and requested to treat her. Further deposed that when he went and saw, the victim was bleeding. Blood had fallen on the ground. Therefore, he asked the accused to take her to the major hospital. He, in the cross examination of PW4, cross examination, such evidence of PW4 could not be impeached in his cross examination. Thereby, the evidence of PW1 about the accused taking the injured victim to the hospital on the bike of PW3 was corroborated by the evidence of PW3 and 4. So far as the cause of death, PW PW10. PW10. The cause of death. The prosecution relied on the evidence of PW10. The doctor who conducted the postmortem examination and his report. PM examination report is report ಅಂತ ಬೇಡ. PM examination report exhibit P. P22. 22 or 22. PW10 ಅಲ್ಲ. ಸರ್ಕಮ್ಸ್ಟೆನ್ಸ್ ಮುಗಿಸ್ಕೊಂಡೇ ಬರೋಣ ಬಿಡಿ. So far as the cause of death ಅಂತ ಹೇಳಿದ್ವಿ.
Cause of death of PW.
Take it later. ಅದು ಬೇಡ, ಆಮೇಲೆ ತಗೊಳ್ಳೋಣ. The evidence of PW1 was further corroborated by the circumstances of the recovery of the dead body. Recovery of the dead body. PW10, the doctor. PW16, the Tahsildar. PW6 and 8, the witnesses to the exhumation Mahazar exhibit P5 spoke that the dead body was the place where the dead body was buried was shown by the accused. They further deposed that on digging there the dead body was found. Regarding that, the Mahazar exhibit P5 was drawn. PW16 and 6 and 8. PW 6, 8, 10 and 16 are all independent witnesses, independent official witnesses. They had no animosity against the accused. Their evidence with regard to the discovery of the dead body at the instance of the accused was not impeached. Discovery of the dead body. Similarly, the fact that PW10 conducted the PM examination on the dead body at the spot was not disputed. PW10, so far as the cause of death, PW10 deposed that there were two 22
So far as cause of death, PW10 reports that there were two.
Well, after conducting the PM examination, he issued the PM report exhibit P22 and his opinion as per exhibit P24. As per his evidence, it was there were fractures. There were compound fractures of left leg tibia bone. Between upper 1/3 and lower 1/3 of tibia bone. The fractures fragments were seen. The second injury was the compound fracture of right leg tibia bone between upper 1/3 and lower 1/3 of the tibia. And there was horizontal and vertical slit. It states both the injuries were antemortem and death was due to hemorrhagic shock secondary to fracture of both tibia. He also gave the opinion that such injuries could be caused if the victim is assaulted with MO6. As already pointed out, the accused himself suggests that the victim died due to the injuries. Due to the accidental injuries, due to the injuries, but they were accidental in nature. The medical evidence with regard to the nature of the injuries was corroborated by the evidence of PW7, the eyewitness. Therefore, there was no reason to disbelieve. Discard the evidence of PW and regarding the cause of death or nature of injuries. Yes, madam. The weapon of offense, MO6, and the blood-stained clothes were seized at the instance of the accused. Those circumstances were proved. By the evidence of PW12, the punch witness, the IO, and the hazards exhibit P11 and 12. Similarly, the circumstance of seizure of bike was also proved by the evidence of PW6 and PW3. Therefore, the case of the if the death was natural, death was due to accidental injuries. There was no reason for there was no reason. In the ordinary course, the accused should have informed her relatives or the villagers. After burying the dead bodies, he leaves the village. All the aforesaid circumstantial evidence coupled with the evidence of eyewitness PW7 likely led the trial court to hold that the charges that the accused is the author of the death and buried the dead body to screen the evidence of the offense. The trial court, on analyzing the circumstances of the accused taking the victim to the hospital and attempting to get her treated, persuaded the trial court to accept that there was no intention on the part of the accused to commit her murder. Therefore, Section 302 IPC does not retract. However, having regard to the gravity of the injuries, the trial court held that the accused had the knowledge that such assault and injuries are such assault or injuries are likely to cause death of the victim. Therefore, the case falls under Part 2 of Section 304. Which IPC? 304 IPC. The trial court, after on sound appreciation of the evidence and supplying sound reasons, has convicted the appellant for the aforesaid offences. This court does not find any ground to interfere with such order of conviction. Next, so far as the sentence, the punishment prescribed for the offence falling under the second part of Section 304 IPC is imprisonment of either description for a term which may extend to 10 years or with fine, or with fine or with both. The trial court has sentenced the accused for the maximum prescribed period of sentence. The disability and one sentence the evidence and record. So far as the inability of the accused to inflict such injuries, the evidence and record shows that the accused had ಅವ್ರ ಫೋಟೋನೇ ಕೈಯಲ್ಲಿ ತೋರಿಸಿದರೆ ಮುಂದಿಂದ ಅಷ್ಟೇ ಇಲ್ಲ. ಹ್ಯಾಡ್ ಡಿಸ್ಫಿಗರ್ಡ್, ಅದು ಡಿಸ್ಫಿಗರ್ಡ್ ಹ್ಯಾಂಡ್ ಇದೆ ಅಷ್ಟೇ, ಡಿಸ್ಫಿಗರ್ಡ್ ರೈಟ್ ರಿಸ್ಟ್. ಅಲ್ಲ ಇಲ್ಲಿದೆ ನೋಡಿ, ತೋರಿಸಿದಾರೆ ಕೈ. ಅಲ್ಲ ಆದ್ರೆ ಅವ್ರು ಹಿ ವಾಸ್ ಡ್ರೈವಿಂಗ್ ದ ಟ್ರ್ಯಾಕ್ಟರ್, ಹಿ ವಾಸ್ ಏನೋ ಜಲ್ಲಿ ಕ್ರಷರ್ ಎಲ್ಲ ಕೆಲಸ ಮಾಡ್ತಿದ್ರು. ವಾಲಂಟ್ರಿ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲ, ಅವ್ರ 313 ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲೇ ಓದಿ ನೀವು. ನಾನು ಜಲ್ಲಿ ಕಲ್ ಹಾಕಿ ಬಂದ್ಮೇಲೆ ಅಲ್ಲಿ ಯಾರೋ ಇದ್ರು ಮನೆಯಲ್ಲಿ ನೋಡೋ, ಹಿ ವಾಸ್ ಡೂಯಿಂಗ್ ದಟ್ ಜಲ್ಲಿ ಕ್ರಶಿಂಗ್ ಜಾಬ್ ಅಂತ ಹೇಳಿದೆ ನಾನು. ಬಂಡೆ ಹೊಡೆಯೋ ಕೆಲಸ ಅಂತ ಇದೆ.
The evidence and record shows that the accused has disfigured right wrist.
Right forehand ಅಂತ ತಗೊಳ್ಳಿ, wrist, right forehand. However, the suggestions made by him to the PW7, ಆಕೆಗೆ ಹೇಳ್ತೀರಾ ನೀವೇ ಅವ್ರನ್ನ ಸಾಕ್ತಿದ್ರಿ ಅಂತ. And his statement under 313 CRPC shows that he was working in a jelly crusher units. He was doing jelly crushing work also. Therefore, there is no merit in the contention that he was incapable of performing any act or assaulting the victim. ಒಂದು ಮಧ್ಯದಲ್ಲಿ ಸೇರಿಸ್ಕೊಳ್ಳೋಣ ಅಪ್ರೋಪ್ರಿಯೇಟ್ ಪ್ಲೇಸಲ್ಲಿ. ಈಗ ಈ ಸೆಂಟೆನ್ಸ್ ಬಗ್ಗೆ ಹೇಳ್ತಾ ಇದ್ದೀನಿ. The mitigating, sorry, at the time of the offense, the accused was, how old was he? ಎಷ್ಟು ವಯಸ್ಸಾಗಿತ್ತು ಅವ್ರಿಗೆ? 34 ಏನೋ ಅಷ್ಟೇ ಇದೆ. ಏಜ್ 34 years. ಟ್ರೈಲ್ ಅಲ್ಲಿ 2015 ಇದರಲ್ಲಿ 34 ವರ್ಷ ಅಂತ. 34 years. 34 years. Okay. He had a minor physical disability. There is some partial physical disability. Despite that, he had given shelter to the deceased and her child, PW7. ಇನ್ನೊಂದು ಮಗುನು ಎಲ್ಲೋ ಅವನ್ ಕೆಲಸ ಮಾಡೋಲ್ಲೇ ಇಟ್ಟಿದ್ದಾರೆ ಅಂತ ಇದೆ. ಲಕ್ಷ್ಮೀ ದೇವಮ್ಮ ಅಂದ್ರೆ ಇವನ್ ತಂಗಿನ? ಲಕ್ಷ್ಮೀ ದೇವಮ್ಮನ ತೋಟದಲ್ಲಿ ಅಂತ ಅಲ್ಲ, ಅದ್ರಲ್ಲೇನೋ ಲಕ್ಷ್ಮೀ ದೇವಮ್ಮ ಮೊದಲು ಅಲ್ಲಿದ್ರು ಇವರು, ಅಲ್ಲಿ ವಾಲಂಟ್ರಿ ಸ್ಟೇಟ್ಮೆಂಟ್ ನಲ್ಲಿ ಮೊದಲು ಅಲ್ಲಿದ್ರು, ಆಮೇಲೆ ಅದನ್ನ ಬಿಟ್ಟು ಈಚೆಗೆ ಬಂದ್ರು ಅಂತ. ವೆರಿ ಅನ್ಫಾರ್ಚುನೇಟ್. ಏನಂದ್ರೆ ನೋಡಿ ಹೆಣ್ಮಕ್ಳ ಪರಿಸ್ಥಿತಿ ಹೇಗಿದೆ.
Despite he had given shelter to deceased and child.
Deceased and her children. So deceased and PW7 and PW7. Further, on assaulting assaulting the victim in the fit of anger, he did all efforts to get her treated. These were the mitigating circumstances in his favor. He has already undergone when he was arrested. ಕಂಪ್ಲೇಂಟ್ ಫೈಲ್ ಮಾಡಿದ್ದೀವಿ ಸರ್. 21/12 ನಾನು ಅರೆಸ್ಟ್ ಮಾಡಿದ್ವಿ. 21 ಅಲ್ಲಿಂದ ಇಲ್ಲಿವರೆಗೂ ಕಸ್ಟಡಿಯಲ್ಲೇ ಇದೆ. ಅರೆಸ್ಟ್ ತೋರಿಸಿದ್ 27 ಅಂದ್ರೆ ಆಯ್ತು. 22/12/2014. Since then he is under detention. So he has already undergone the imprisonment of far more than 7 years. 7 years. 7 years 2 months. 2 months and above. So 7 years 2 months. 2 months. ಇನ್ನೊಂದು 10 ತಿಂಗಳು ಇದ್ದು ಬರ್ಲಿ ಬಿಡಿ. ಇದು ನಮಗೂ ಓನ್ಲಿ ಸನ್ ಇಲ್ಲ ರೀ, ಅವ್ನ ವಾಲಂಟ್ರಿ ಸ್ಟೇಟ್ಮೆಂಟ್ ನಲ್ಲಿ ಅವ್ನಿಗೆ ಅಕ್ಕ ತಂಗಿ ಯಾರೋ ಇದಾರೆ ಅಂತ ಬಂದಿದೆ. ಮತ್ ಇವ್ರ್ಯಾರ ಏನ್ ಮಾಡ್ತಾರೆ ಅಂತ ತಿಳ್ಕೊಂಡಿದೀರಿ? ಇವ್ರು ಹಾಗಿದ್ರೆ ಅಲ್ಲ, ಹೇಗಾದ್ರೂ ಮುಚ್ಚಾಕಿ ಯಾರು ಸಂಬಂಧಿಕರಿಗೆಲ್ಲ ಯಾಕೆ ಹೇಳಿಲ್ಲ? ಸುಮ್ನೆ ಯಾಕೆ ಸೇರಿಸ್ತಾರೆ ಇವ್ರ ಕೇಸಲ್ಲಿ? ಅಲ್ಲ, ಸುಮ್ನೆ ಯಾಕೆ ವಾಲಂಟ್ರಿ ಸ್ಟೇಟ್ಮೆಂಟ್ ಇಸ್ ಎಕ್ಸಿಬಿಟ್ ಪಿ. ಅಲ್ಲ, ಹುಡುಗಿನ ಎವಿಡೆನ್ಸ್ ಕೊಡ್ತಾಳೆ ಆಗಿರುತ್ತೆ ನೋಡಿ. ಅವ್ರ ಕ್ಲಾಸೇ ಆಗಿತ್ತು. ಬೋತ್ ಆಫ್ ದೆಮ್ ಬಿಲಾಂಗ್ ಟು ದಟ್ ಕ್ಲಾಸ್. ಎಕ್ಸಿಬಿಟ್ ಎಷ್ಟದು? ಎಕ್ಸಿಬಿಟ್ P38. ಅಲ್ಲ, ಮಾರ್ಕ್ ಮಾಡಿದ್ರಲ್ಲೆಲ್ಲ ನಮ್ಗೆ ಪೇಪರ್ ಬುಕ್ ಅಲ್ಲಿ ಇಲ್ಲ ನಮ್ಗೆ. P30 ROPSY 30 ಕರೆಕ್ಟ್. ಮಕ್ಕಳ ಗತಿ ಏನ್ ಹೇಳ್ರಿ? ಪೇಪರ್ ಬುಕ್ ಇಲ್ಲದೆ ಇರೋದ್ರೆ ನಮಗೂ ಸ್ವಲ್ಪ ಕಷ್ಟ ಆಗಿದೆ. ಇಲ್ಲ, P30 ಅಂತ ನಿಮಗ್ ಓದ್ ತೋರಿಸ್ಬೇಕಾಗಿತ್ತು ನಾವು. ನೋಡಿ, ನನ್ನ ತಂದೆ ಗಂಗಪ್ಪ, ತಾಯಿ ಗೌರಮ್ಮ ಇವರಿಗೆ 1ನೇ ಮುತ್ತಮ್ಮ, 2ನೇ ನಾನು, 3ನೇ ಈರಮ್ಮ, 4ನೇ ಶಂಕರ ಎಂಬ ಮಕ್ಕಳಿರುತ್ತೇವೆ. ನನ್ನ ಅಕ್ಕ ತಂಗಿಗೆ ಮದುವೆ ಮಾಡಿದ್ದು ನನ್ನ ತಂಗಿ ಈರಮ್ಮ ಗಂಡನ ಮನೆಯಲ್ಲಿ ಇದ್ದಾಳೆ. ನನ್ನ ಅಕ್ಕ ಮುತ್ತಮ್ಮಳ ಗಂಡ ತೀರಿ ಹೋಗಿದ್ದರಿಂದ ನಮ್ಮ ತಂದೆ ತಾಯಿ ಜೊತೆಯಲ್ಲಿ ಇರುತ್ತಾಳೆ. ನನ್ನ ಬಲಮುಂಗ ಅಂಗವಿಕಲತೆ ಆಗಿದ್ದು ಬಲಕೈ ಸಪೋರ್ಟ್ ತೆಗೆದುಕೊಂಡು ಎಡಕೈಯಿಂದ ಬಂಡೇಜ್ ಅಲ್ಲಿ ಮತ್ತು ಸೈಜ್ ಕಲ್ಲೊಡೆಯುವ ಕೆಲಸ ಮಾಡಿಕೊಂಡಿರುತ್ತೇನೆ. ಅವ್ನು 4 ವರ್ಷದಿಂದನೇ ಮನೆ ಬಿಟ್ಟಿದ್ದಾನೆ ಅಂತ ಹೇಳ್ತಾರೆ. ತನ್ನ ಮನೆ ಬಿಟ್ಟು ಮಾಗಿಗಿಲ್ಲ ಅಂದ್ರೆ ನೀವು ತಂದೆ ತಾಯಿನ ಒಬ್ಬರೇ ನೋಡ್ಕೊಂತಿದ್ರು ಅಂತ ಹೇಳಿ.
He has already undergone imprisonment for more than 7 years, 2 months.
2 months. ಆ ಫೈನ್ ಅಮೌಂಟ್ ಅರ ಕಟ್ಟಬೇಕಲ್ಲ ನೀವು. ಈಗ ಅನ್ಕೊಂಡಷ್ಟು ಹೋಗುತ್ತೆ. Except this case, he has no other criminal antecedents. Having regard to the affected facts and circumstances, this court finds this just and appropriate to confine the period of sentence, confine the sentence of imprisonment to the period of detention also already undergone by him. Therefore, the appeal is partly allowed. The impugned order of conviction is hereby set aside. The impugned order of sentence for offense under section 201 CH-8 is confirmed. The impugned order of sentence of imprisonment for the offense punishable under section 304 IPC is modified. Sentence is confined to the period of detention already undergone by him. The order with regard to sentence of imprisonment, sentence of fine, or disposal of property, sentence of imprisonment, rest of the order with regard to the rest of the order is maintained. Rest in the order with regard to the sentence of fine and disposal of the property, the set off are hereby the maintained ಅಂತ maintained ಅಂತ ಹೇಳಿದೇವಲ್ಲ. ಹೌದು, ಅದು ಸರಿ. The trial court shall, the accused shall be set at liberty forthwith if his detention is not required. ಅಲ್ಲ, ಅದು ನೀವು ಫೈನ್ ಕಟ್ಟಿದ್ರೆ set at liberty forthwith subject to the deposit of the fine amount, the accused shall be set at liberty forthwith if his detention is not required in any other case.